inadvertent change to our policies. 3.26 complies with Michigan Sex Education Statute. Previously, the law and our policy had it where staff could not direct any students for an abortion. That was not made clear that this was a decision that we could keep. Most schools kept their policies on their books that staff would not direct any students for abortion or any kind of abortion care. And added to this were many concerns that have been raised about parental rights. And I think what this encapsulates is basically the understanding of most parents with the actions by the school at this time. And so we could just dive right into it. So we want to just go through his questions or go through his sections. John, you want to possibly lead us off?
I think the biggest piece is on the purpose section. There's a citation to the revised school code, specifically section 10 of the revised school code, which has been in the law for a long time and codifies the rights of parents, legal guardians in Michigan. And what that statute states is that it's the natural and fundamental right of parents and legal guardians to direct the care, teaching, and education of their children. And then it further states that public schools of the state serve the needs of pupils or students by cooperating with the students, parents, and legal guardian to develop the pupils' or students' intellectual capabilities and vocational skills in a safe and positive environment. So that's language that's been in the revised school code for a long time. And in the purpose section, that is restated here as part of the purpose of this policy. And my understanding of the drafting of it was to ensure that the board is following the requirements of that section of the revised school code. And then that purpose section goes on to, after the statutory site, to talk about a further purpose is to ensure that parents who obviously have legal custody of their child are the primary decision makers regarding the concern of their child's welfare and their education, and therefore can make decisions regarding their health care, both physical, mental, and which aligns with that section of the revised school code. So that's the high level when you look at this, that revised school code section comes into play, and then obviously the language of the statute that Mr. Cotton read that had been taken out, that there's no longer a requirement and a state aid penalty to have language that says a individual employee cannot refer a student for an abortion, but it certainly does not limit a school district from having such a policy.
I have a question.
Sure.
Just the general concept of parental involvement makes complete sense, and the notion in here is an exception for the law. And chasing that down, the mental health professional, is that a defined term? Who in the school fits within that category?
So, I believe that language as exception is somewhat of a catch-all. In a mental health professional, typically you're talking about a private therapist that an individual student is, or individual person in general is going to see. But in drafting the policy and looking at ensuring that if in fact there is an individual who might have a doctorate of psychology or something to that effect who is otherwise seeing a student in our buildings, there potentially could be an exception for that individual. It doesn't automatically apply to a guidance counselor, for example.
So, well, my thought being the exception should be broad enough to protect the kids if there's abuse. In fact, when our daughter was in high school, she had a friend. One parent was an alcoholic and the other one wasn't around. And she spent a couple of nights at our house because it was safer. So that concept, right, an exception for that concept. And there's an exception in here for the law, right? But the law talks about mental health professional. Well, if nobody on staff fits within that exception, the exception doesn't do anything to address this abuse issue for the school.
So I think you're looking at two different issues in that circumstance. So the exception here in section or MCL 330.1707 specifically refers to mental health professionals and their obligation to a student who is 14 years of age or older. What you're talking about, one of the example you gave, is an issue where there is abuse going on in the home potentially, which if we talk about mandatory reporters in our school districts and in Grosse Pointe public school system, almost all of our employees are mandatory reporters, which is addressed completely in other sections of our board policy, that if there is any belief that there is child abuse or neglect, there's an obligation to report that both to the Michigan Department of Health and Human Services and, depending on the potential abuse, potentially police as well. And that's while it's been in place for a long time, is addressed in separate policies. And so, regardless of if this policy were to have an exception or not, if any staff member, teacher, social worker, et cetera, believes that there is abuse going on or neglect as a result of any issue a student were to bring up, we'd have an obligation, affirmative obligation, to report that within 72 hours as employees of the school district.
They answered my next question about reporting. So the part where it says contrary to board policy, that would pick up the reporting you just talked about.
Correct.
Then would the school still have to report it to the parents? So you've got an abuse situation, reporting requirement triggers reporting.
Sure.
Does this then trigger notifying parents?
So,
Which one controls?
yeah, so part of the issue you end up having is the reporting obligation comes from state law and the child protection statutes. And so if in fact there is a circumstance where that law were to preempt a situation, so preemption means the state law controls prior to board policy, then there potentially would be a time, that could be an exception. Those are very rare circumstances. And so for example, regardless of this policy and what this policy says about notification to parents for physical well-being, mental well-being, identification, etc., if any of our staff members are reporting issues of abuse, there's always going to be a case-by-case basis where there's a discussion, and this wouldn't happen in a vacuum, and I don't want to speak for Dr. Tuttle and her team, but I mean, typically when these are ongoing, you have a teacher talking to an administrator who may be talking to other individuals who know that student to determine what are the specific facts regarding the allegations and why there's a report taking place, and then depending on the circumstances, when and if a parent would be notified, because part of the law on reporting states that the information that is reported and the individual who does report is confidential in nature. So if an individual is reporting something, they wouldn't be then going to a parent and saying, I reported this to CPS, for example. And I don't want to speak for Dr. Tuttle and her team, but I think it's a collaborative approach to that.
It's my understanding there are some people on staff that are not mandatory reporters. Is that correct?
So you potentially, technically yes. So our office's recommendation to all our school district clients is to ensure that every staff member, as much as possible, is aware of obligations regarding mandatory reporters. But there are, when you look at the statute itself, it doesn't necessarily call out custodians, for example, or third-party contractors, depending on the position they're in. It talks about teachers, administrators, social workers, counselors. So there are some groups that potentially are not mandatory reporters. That is not to say that they shouldn't be made aware that others are mandatory reporters, and it's always good to make sure people are aware of obligations regarding child abuse and neglect.
What do we currently do? So I'm looking at the physical health matters section. How does the district currently handle a situation where there's any kind of a physical health issue with a student? So somebody falls off the jungle gym and breaks their foot, or has any other ailment. But what's the current process of notifying or not notifying parents of something?
I think parents are notified on most circumstances, especially the ones that you just described. We try to keep parents informed as much as possible, excluding if we think a child is being abused by the parent or something of that nature.
And also as a parent, you sign off a waiver with the school system upon enrollment that the school district can act immediately in an emergency, or you also can withhold that and say, no, a parent has to be involved. I think most parents sign that waiver off saying the school district can immediately act to send a student to the hospital.
So does anything about the, I guess any of these policies change what happens in practice? Under the, I guess under current school policy.
I'm a little hesitant to answer that because I would like to say I do not believe so. However, I have not been in conversations with principals with regard to some of these, so I'm not sure. We should be following current policy, so I would hope that our administrators are doing so. But I have not heard any violations of policies. So I would suspect that they are just following the current policy of the board, and that's what we're directed to do.
Okay. I guess my last question really, well, I guess I have two follow-up questions. One, is there any standardized communication out to parents? I'm just looking at the notifications to parents. Is there anything that the district does, like if we look at the mental health matters section, if there's a concern relating to mental health, we're going to notify parents. Does the district have any standard way that they notify parents of either that the child talked to a counselor about something specific? Do they name something, whatever it was that was discussed, or just, hey, your child came in, talked to this person, you should probably follow up?
If I understand your question correctly, I think, again, that the staff members are going to follow the policies and the law. Obviously, law supersedes policies, correct me if I'm wrong. And so there's constant training. The laws change and policies change, as we're here today talking about those. So as far as specific protocols that are written down that this, if X happens, Y happens, there are so many nuanced situations in schools that I guess I would answer that by saying, to the best of our abilities, we let parents know.
Okay.
Now, if we think a child is in danger, obviously, I think that would change our protocol. And I'm never hesitant to call an attorney to see what the legal obligations are as well. And I would hope, and I have not found any of these situations yet, but I would hope that any administrator, if they were concerned, would call me and we would talk through the process. Deputy Superintendent, Dr. Bishop, the attorneys, before, if we're concerned that we're not following protocols or if we're abiding by the laws and the policies and we're protecting the kids.
Okay.
And I would hope that our first thing was to protect students, and that's always my first go-to, so.
I just want to confirm, John, there's nothing in this entire policy follows the law of Michigan and federal, correct?
Correct, yeah, there's nothing in this that is in violation of any federal or state statutes.
My last question, and this is more overarching, I guess, related to the physical health matters, but the mandatory reporting laws, I'm not familiar enough with them. Sure. But if a 15-year-old comes in and is pregnant in school, I think by law, and I could be completely wrong on this, but the age of consent in Michigan is 16. So what happens if there's a 15-year-old that's pregnant? Does that trigger mandatory reporting in any way, or?
Yeah, so most likely it would, so if technically a 15-year-old is not able to consent, so it would be considered what is commonly referred to as statutory rape. So in our office's recommendation would be to report. Child Protective Services in Michigan always expects over-reporting, and that's the way the statute is set up. It's not for employees of the district to make determinations as to whether or not abuse or neglect took place. It's whether or not, as a reasonable person in their position, they believe it could have taken place, and then let the professionals make that determination. And if a 15-year-old is providing that information to us, it's let another professional who's in Child Protective Services make that determination.
Okay.
Do you know what happens if it's a 16-year-old?
So it gets a little different, depends on what potential the facts are that come before us, right? So when you talk about the age of consent, you also get into an issue of What was the age of the other individual potentially? Who was the other individual? So there technically still could potentially be a reporting obligation for us or for employees of the district to protective services because there still can be potential criminal actions even if a student or if a student is 16. If, for example, there is engagement with someone else who is an employee or contractor of the district, for example. So it's a fact-by-fact basis, but under the way the policy is drafted, there would be reporting because it's someone who was under the age of 18. When I say reporting, the parent would be notified under this policy because there's nothing that would prohibit any notification, and there's nothing in the law that prohibits a district, if you have a policy like this, from notifying a parent of a 16-year-old.
And I mean, my understanding is that nobody in the district has asked for or would like or is interested in having that ability to refer a student for an abortion. And so, I mean, that's where we looked at making sure that this policy was revised correctly. And we're going to have this policy meeting. If this goes forward, there'll be time for people to get to the board and talk to the board. Also at the board meetings, bring it up. But I still have yet to hear from anybody after that inadvertent change that they would want that ability. I do wonder if it's something that in our counseling, we at least provide a student with some kind of notification what the law is. And do school districts do that? And the fact that somebody is in charge of their own reproductive rights at a age majority level, regardless of whether or not they are 18.
Yeah, I mean, so that's a possibility. I mean, so and that would go something beyond necessarily this policy, for example, right? And so that I think that would be something that, if this policy goes through, and that's something that is a question that's outstanding. It's not necessarily within this policy, but referring back to Dr. Tuttle for what makes sense for your teams at the high schools as far as the counseling departments and obviously with other central administrators and what would be appropriate to have for them in those particular buildings based on their experiences.
Thoughts, comments?
Just one other quick comment on what you said about abortion referrals. So, worked with school districts for a long time, myself and our office have. And when the law changed such that you were required to have a policy that said you could not have any employees refer a student for an abortion, or you had a state aid penalty, there was a lot of proactive information, both from school districts but also from the unions who represent teachers and other employees of the district. So you've got the MEA, but you also have the American Federation of Teachers and SEIU and various other unions, making sure that their members were aware of that because there was pretty stringent penalties and not everyone knew who would potentially was talking individually to a student. So that was out there. And say when the law was repealed, and I saw that a lot back then, and when the law was repealed, I have not seen that same thing, hey, now you can go refer students for abortions. It's not being promoted out there. And so to your point about people talking about it, it's just not as prevalent when it happened the opposite way.
I think my only, a follow-up or recommendation would be to have some sort of directive to the administration to create some initial standard for communication with parents. However that is to be communicated. We talk about, if I'm looking at mental health, for example, if a minor student raises concerns, then the parent will be promptly notified. And I don't know if the right path forward is to notify the parent of exactly what the student raised as their concern, or if it's to notify the parent that, hey, your child came in, saw the counselor, we would recommend that you talk to somebody else. But I think that if the administration can standardize or formalize something as part of this policy so that you're still protecting some level of confidentiality and trust with the student and the faculty, whoever they're confiding in, but also giving the parents enough resources to help the student at home. I don't know how that would work in practice, so.
I'm trying to
So, but
decipher
I-
that. There's, like
I
I said,
also-
everything's very nuanced.
Yeah.
Every situation brings a variety of different factors to it, and we often act in local parentis parente to make decisions. And as I said, our first goal is to protect the child, but parents, to your point, if a child is suicidal, we're letting the parent know.
Right.
But if we thought that they were suicidal because of something that happened at home, we would do a mandatory reporting. So that's where the protection is of home issues that are going to interfere. So I don't know if that answers your question, but it's really hard to make a standardized, there are so many decisions that we have to make that are based on a variety of different variables. Every kid is unique, every situation is unique. So I hear you. I wish that was as easy said and done and that we could do something, but
I mean, if a kid comes in and says, I'm depressed, versus suicidal, right? Those are kind of two different categories of approaching the counseling staff. So I guess that's kind of my thought is, however it gets notified, maybe, like, is it appropriate to notify the parent that, hey, your child came in and complained of depression? Or is it more appropriate to notify the parent, your child came in and we think that you should go see a psychiatrist or an outside counselor or something like that?
I don't want to speak for all of our schools, and obviously if the depression was stemming from a home situation, that's different. But if the child is depressed because of something at school, I would hope that a parent would be notified, hey, we have concerns, and we have concerns. I would want to know as a parent that I can assist my child in some fashion. But if we thought the concerns were related to home situations, that are the nuanced situations that we have to think about how we're going to address that.
Just to maybe, pound on that, as Dr. Tuttle said, there are so many different nuanced issues that come up, but, if there's enough similar reporting from the same student about depression, that could trigger some other potential issues for us, whether or not there's potentially a review of some sort of emotional impairment or something else. So there's a lot of federal laws that govern just how we operate as a district, including if a student needs additional resources through either the special ed department or a Section 504 plan. So there's a lot of other things that come into play with this too.
Otherwise,
Which would,
compared, there's a
correct.
variety of different
which
things
would
that-
also trigger parent notification too.
No, you're absolutely right. I think that's-
Kind of connected with that, and then looping back to the overarching mental health issue. Yeah, I was wondering what was meant by that. Like, if a parent requested it, they said, I want you to record the conversations with my child. Could they request that? Is it just relaying, here's what we talked about? Is it just relaying, your child came to see me? We know that we all want to respect the parents and their authority, their primary role. I've been teaching long enough. I've had parents who, when I relay concerns, the parent will say, it's not a problem. And could they actually, can they say, I don't want my child seeing this counselor, and just cut that off? Could they say, I don't want you to talk about X, Y, or Z with my child, and have like a menu of things that child can open up and talk about and is not allowed to talk about? I'm kind of concerned how this might be interpreted as is. I'm hopeful we can get our counselors and our school psychologists as part of this conversation, because I've had students who are clearly depressed, and it's not my role to try to advise and counsel them. I'm a classroom teacher, but when I've relayed, looped in the parent and counselor in the conversation, again, sometimes the parents will say it's not a problem, or we're taking care of it. And what I encounter in the classroom relays, it's clearly still, it's problematic. We sometimes have student behavior that gets a student down to the main office, and when a call is made home, the parent might say, don't bother my child, don't call me at work, or I've got it under control, just send them back to class. And I know it's a difficult situation for us to navigate, but I'm just concerned that some of this, in terms of how things will be documented or deferring to the parent's directives. I mean, if we have a parent who is mentally unwell, and maybe it's not direct abuse, but maybe they're ignoring a child's mental or physical health and it's manifesting during the school day. It's tough. I don't claim to have the answers, but I'm hoping we can get our counselors and school psychologists on board and talk about what we are. My understanding is we actually have a newer curriculum, at least at the high school, for how we navigate student health issues, physical and mental health issues. So if that can be part of the conversation too, if there's anything we need that needs to be updated or refined.
What do you mean by newer curriculum?
My understanding is, for example, with our freshmen, our counselors visit the classes and just have simple, quick mental health conversations. It's actually, I believe it's just once a year, but it usually involves some proven strategies for reducing stress, managing your workload, your study load, dealing with difficult social situations. So some everyday
Coping skills.
yeah, life strategies. And I don't think many of us would begrudge that as part of an education, learning to interact with others and learning how to deal with stress and different things. But I guess I'm concerned with how some of this might be interpreted or how we might be held liable if someone says, not to talk to my child at all about this, or if this mental health situation doesn't exist, we're not going to talk about it, even if they ask about it. Or, I want things recorded. My interpretation of documented is I want when they come to see you, I want a recording. I want a play-by-play. And just kind of, some of our kids talk to the counselors because life at home is difficult, and I trust that our counselors, they're not brainwashing or telling the kids what to do, but they have a repertoire of coping strategies and general advice and ideas. I'm just
You would
concerned.
check from a legal standpoint, which I think his questions.
Yeah, so I think a couple of items, so you're raising some points that potentially talk about if there's conflicts from other policies or laws with this policy, with this particular policy. That happens across the board from time to time. We've talked about some of it here already. And that we have to meld those together. And so you got federal law, and state law, and local law, and board policy. And for example, some of the circumstances you gave. So if a student is manifesting physical and mental concerns to teachers on a regular basis, that potentially could be cause for a report for child abuse, right? I mean, and that triggers an obligation, an affirmative obligation we have as a teacher or a counselor to report that. And obviously that's a pretty serious circumstance, but that potentially could take place, and so therefore we got to report it, right? The other piece is that we are informing parents under this policy, but we can't force them to how they're going to react to anything, right? And so parents, for example, have the right to direct, and there's some very specific information on this about sexual education, for example, right? So if they're saying, you can't talk to my student about X, Y, or Z, and it relates to sexual education, we know that fits into one particular area.
That's the law, right?
Right, exactly. And then if you start getting into, obviously there's a whole bunch of different circumstances that you could go on from there, and it's going to become a fact-by-fact situation on whether or not it's legal or not legal. Going to the recording aspect, for example, there's also provisions in various other policies regarding recordings and collective bargaining agreements, such that a teacher can't just be forced to be recorded at any time, and you have to consent to that as well. So documentation is emails, written correspondence. You don't have to agree to be recorded every time, and if you wanted to get into details about the recordings and IEPs or some other, all sorts of different things that come into play in that too. So we just have to take it on a case by case basis, based on the facts. But there's going to be potentially other laws that could come into play as well.
And parents are always involved in an IEP, correct?
I mean, they're always invited. They're required to be invited, yes.
I guess I'm just concerned that putting it formally, kind of adding some of this to our policy, it does create, it seems like it would create liabilities for us that don't currently exist. It creates some things that with the parent taking the lead and administration deferring, what are the boundaries for what would be considered like a mental health crisis versus, oh, they're just going through a phase? Who gets to decide? Do we bring on people on board? Do we not trust our counselors and psychologists when they say we need to navigate this? Like if a parent says, nope, I've got it under control.
Yeah, and so that again, get into some details here, but like if we believe there's a mental health crisis such that there should be a recommendation for some sort of, at least an evaluation that could lead to an IEP, and a parent will not agree to it. There's a whole process, litigation process that a school district can go through to actually require the evaluation process. It doesn't happen very often, but that there is a process to do that. That would be something that would supersede this policy because the law is coming into play as far as recommendations from the IEP team, right? And it's called a Hanukkah injunction. There's a whole process for that. I don't know if you have anything else on that.
But I've been involved in those. No, and to your point, I think it goes back to if we think that the kid is being abused at home, that's causing, why doesn't the parent, as Attorney Kava said, I'm always an advocate of over-reporting. Let the experts investigate and provide us guidance. Sometimes they look at it and say, we're not going to do anything further, as you know. And sometimes they investigate it and then they kind of take the lead on that as experts. But definitely, very nuanced for our counselors. I get it. It's hard. Yeah. But if they think a child is being mistreated or not being treated properly with conditions, they can certainly report that, and I would recommend that.
Going back to the liability issue, what are, if any, the district's liabilities if something does not get reported to the parents? So as it stands right now, and I'll continue on with the mental health issue. Sure. If a student comes, talks to a counselor about being depressed or thinking they have depression, and the district does not notify the parent of that. And let's say it happens 3 or 4 times. Right? I'm not saying that the counselors would not. I think at some point, common sense takes over. But if they did not, and something happened to that child outside of school related to that, and the district had documented knowledge of it, what kind of liabilities does the district face?
Yeah, so when we start talking about district liability for certain actions like that, it really becomes is a district on notice, who is on notice, and then what do we do about it once we are on notice? And notifying the parents could be one thing. There could be other referrals and that type of thing. But essentially the question is once we're on notice, do we act in a manner such that we acted with deliberate indifference? When I say we, the individuals who are aware of it, acted with deliberate indifference. And if that's the case, then potentially there could be liability. And so, big picture, district has insurance policies in place that cover the district as a whole, board members, administrators, teachers. And general rule is insurance will cover any suit provided you're acting within the scope of your employment and you're not acting in a grossly negligent manner or intentionally acting with misconduct. So if you're just plain negligence, typically you're covered, and you're covered by governmental immunity as well. Right? Brought up the deliberate indifference standard because that's where courts have said individuals have acted in a grossly negligent manner if they've acted deliberately indifferent, meaning they're on notice and just have done nothing to prevent what could have been foreseen as a preventable circumstance.
Just a dumb question. If teachers, staff, somebody who violates a school policy, is that, how is that used in court? Is that a presumption of something? Does it matter? Does it create liability in and of itself?
Would depend on the factual circumstances. So, I mean, in general, kind of taking it more at the local level, if an individual employee does not follow a board policy, they potentially are subject to discipline for not following board policy. That's with any board policy in general. Getting into a liability from a court perspective, it would get into what was the policy that wasn't followed. So if on the Child Protective Services reporting requirement, if we are on notice that, when I say we, again, an individual employee who is a mandatory reporter, that a reasonable person will believe there's child abuse or neglect, and they do not report it as required by the law and our policy, they're subject to criminal and civil penalties. Not following this particular policy before you doesn't automatically subject to someone to criminal or civil penalties because there's not a further mechanism in the law with respect to it. I would say, however, this policy does put guardrails around the revised school code provision that parents are the ones who have the right to direct the education of their students, and in general, not following the revised school code can be considered a misdemeanor by individual employees of the district. I mean, so this policy implements the revised school code section. One could argue if you're not following the revised school code, there's a misdemeanor behind it. The revised school code doesn't say a parent needs to be notified for all these issues. This policy is further implementing that, so I think it would be hard to establish that. But the bigger question would be is if parents aren't notified, I'd be more concerned with the issue of is if they aren't notified of something that led to some grave harm to a student when we were on notice and acted deliberately indifferent, that's when we've got some larger issues are.
Other thoughts or comments?
I'm just curious, when you mentioned, it was interesting that there would be some parents that would say, don't engage with the child, it's okay, and that kind of thing. So, does it happen to you? Do you come across something like that?
Yes.
And out of how many times that's come across, how many times that's, you've observed something that caused you to feel there's something might be going on there, they've come to you and said something, how many times has the parent said, don't engage?
It has happened just a handful of times in my career, but they are all memorable, obviously. And I, of course, if I feel it's a possible abuse situation, I've related to the counselors and our admin, but that's what, in an ideal world, we're all gonna care about and listen to and support our kids and reorient them if needed with some advice and suggestions and ideas. But with staff required to defer to and support the parents' directives. And again, we sometimes have parents who are they are not mentally well. And that's not, we all have ebbs and flows in our own mental health throughout our lives, but yeah, it's scary when the parent says, it's not a problem. Now, how are we going to get this grade up to an A? Or I've had a student who, I won't relay specific details for obvious reasons, I want to protect that, but some behaviors in class, and I had a parent slam a fist on the table and say, we're moving on, next subject. And even if it's not overtly what I suspect to be a physical or a mental abuse situation, I'm just concerned if a parent says you're not to talk about this at all, or you're not to see your counselor, or you're not to get this support. I'm just kind of concerned that we might have some kids who are missing out on somebody they can talk to and somebody who can just help them logically unpack a tough situation they might be going through. It does happen. I'll tell you, at the start of my career, if you remember the film Dead Poets Society, and by the way, I don't advocate Mr. Keating's teaching approaches in their entirety, but there's a scene where one of the parents tells his son, who going to Harvard, and you're gonna be a doctor. And when I first saw that film, I thought that is so over the top. There are parents like that out there who they see their children as just extensions of themselves and not as individuals. And we want to help our kids get a sense of who they are and help them through life. I know all of us do. And I'm kind of concerned that some of this might be misinterpreted or interpreted broadly as a way to cut off some of those conversations or some of the possibilities, including with the parents, not hiding anything from the parents, but just a parent cutting it off early and the student really struggling.
Other thoughts or? All right, we'll open this up to public comment. Do 2 minutes, and it's purely public comment. And if you have want to give any details on if you have kids in the district currently, that'd be great. And we'll start with anyone want to give public comment? No?
I will.
Okay, could you stand and state your name?
Sure. I'm Maureen Krasner. I don't have kids in the district. I have 2 graduates, one of which had the great honor to have Mr. Cox for his teacher for a few different classes. And listening to Mr. Cox speak to all of you about what's important, I hope really resonates, because our teachers and our counselors are there, they're doing the things. We haven't had the opportunity to look at the policy to know even what you're speaking of. I don't know if there's anything in it around divorced parents or different rights around that. I don't know what other things are in it. I'm not quite sure what it's addressing. It's not entirely clear, but again, maybe reading it, that would be more clear. So that's what I'll just say, that I hope that we take a step back, that we listen to our teachers, that we listen to our counselors. I'm curious, and I know I'm not allowed to ask questions necessarily, it's pure public comment, but if Mr. Kava, if you drafted this and if other districts are using a similar policy, that would be interesting to know what, how that's interpreted and how that's used. So I thank you all for your service, and particularly Mr. Cox, thank you.
All right, anyone else? Yes?
My name is Christine Poole. I'm a school psychologist at Grosse Pointe North High School. I have 2 students in the district, one at Grosse Pointe South and one right here at Brownell. I find it deeply concerning that we're talking about this policy. The community hasn't seen it. And me, as a school psychologist in this district for 15 years, haven't even heard about this policy until today. So I find that deeply concerning, and would like you all to know how concerning that is. I haven't spoken to a single person at this table about what this means for my practice or my colleagues' practice, and I think that's irresponsible. So that's all I have to say.
Okay, anyone else? Yes?
Hi. I'm Meg Leonard. I am from Grosse Pointe Farms, live in Grosse Pointe Farms. My father was a school teacher here for 30 plus years at Grosse Pointe South. I have graduated 3 kids through the district. One is a sophomore currently at Grosse Pointe South. We've had Mr. Cox as well. Go English majors.
That's right.
And I guess I just speak really simply about just the concept of parents, particularly parents in our community. I would have to believe that the vast majority of parents are engaged and loving and compassionate and would certainly jump into action if school notified them that something was going on. I would certainly be beyond grateful to have that. And I have had teachers notice things in the past that have come up, and it's been wonderful, and it's been a partnership. And what I would like to see continue is that there isn't a value placed on who knows better, if teachers and counselors are better judges of parents, or parents are better judges of what goes on in the classroom than that. I would truly like to see a partnership continue between parents and staff within our public education system. And that somehow, as a policy is addressed, we hit that sweet spot and what it is. I understand there's nuances in here that, I mean, we can't even imagine, that those of us not in the classroom or in a counseling office, I can only imagine. And certainly you would want to protect kids who, you know, have dangerous home situations, obviously. But I would say there was an incident once when I was at Brownell where my daughter was about to be brought in by one counselor about something based on an accusation from another student. Honestly, that was a false accusation. And my daughter was in a little bit of a precarious place. It would not have been ideal for her to be pulled in and spoken to. And another counselor intervened and said, whoa, 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 I know what's going on with that student. No, let's talk to the parents. I got a phone call, they engaged me, the whole situation was resolved. But I have to say, it was a tale of two cities. One didn't want to engage me and one did, and the difference maker was my engagement. And it was something that was really readily resolved. So I would just send out a plea to that there really isn't all this division over who has agency over our kids. It's a partnership. Certainly, my belief is the parents have the ultimate decision as, you know, the stewards and parents of these kids, but I would love to see partnership in whatever gets created.
Hey, anybody? Yes?
Not completely understanding the language, but being a teacher for 26 years and knowing the resources that school psychologists provide and counselors provide and teachers provide, it's a burden that we carry willingly to try to help kids. If the language in here is about providing a clear path to getting kids help, then I'm way for it. And I think as a teacher, one of the things that we wrestle with all the time is how to act in accordance with the law, with the needs of the parents, with the needs of the kids, when to follow like what we trust, and it's very ambiguous at times and very clear at other times. But anything that would allow language that would make it clearer for us to help kids, I would be in favor of as a teacher, because you know, one thing I tell my players and my students right up front at the beginning of the year is, you shouldn't have an expectation of privacy when you come to me about things. That I am a servant of the district, and that I have an obligation to follow the paths that would help you and guide you the best way possible. That I'm not that instrument. So, you know, not knowing everything involved here, I would say that if there's language that would make that clearer for teachers and clearly set the boundaries of what we can and cannot do, and get us on a path to get kids to the right people to help them, that's something that I would encourage.
Anyone else?
I do
Yes.
want to make one more comment. I don't know how practical it is to ask for public comment on a policy you have not published. None of us have any idea what you're talking about. Maybe it has the language he wants. Nobody knows. You didn't even give us 24 hours notice of this meeting. And then when it was published that we were having this meeting, this particular agenda item was not added until mere hours before I had to drop out of a meeting with my intellectual property counsel, which is not going to be cheap, and to be able to make it here just at the tail end. What are we even addressing at this point? How much can we really be saying we respect the parents and we want parents involved and we want parents to lead if we won't tell the parents what the hell we're doing?
Anyone else? Yes.
There's a few groups of people that have to follow state of Michigan laws to protect children, or they could go to jail. Whatever you guys come up with, you know, make sure you follow all of the laws. Because if you miss one thing, there is an employee that can go to jail, no doubt about that. You know, I worked in healthcare for a little bit, and the mental illness that you see, you don't even realize what's going on. And if you get a kid that's depressed, you know, his chances of recovery are dependent on, you know, getting service pretty quickly. You know, and sometimes when people get a little better, that's when they're most likely to take things and go very badly. But as far as nurses and teachers, and I think there's a couple of other groups, you guys gotta follow the laws. So whatever you guys come up with, just make sure you guys follow the laws. And there's lots of mental illness that you don't even realize is going on, you know, because it manifests in so many different ways. You know, I personally seen a kid chew on his hair. This kid was markedly depressed, and you think chewing on hair is no big deal, but when you have to do a thoracotomy, opening up the chest to get that blockage out of the esophagus. So there's things that teachers and nurses and doctors and the other groups, you know, you got to rely on specialists as quickly as you can. You know, get the parents involved. Protect yourselves.
I have something to say in response to that. Are we protecting these people at the table, or are we protecting our kids? When is this going to be about our kids and not about the agendas and the political divide and the them against us and the teachers against the parents and the counselors against the parents? I'm really getting tired of hearing the same rhetoric, and I'm really looking forward to the day where our children are put first and not all your agendas. Thank you.
Yes.
Most parents send their children to school expecting that, knowing that they are the primary caregiver, and they do want the courtesy of being told if there's anything concerning. So just make sure the parents are told if you see something that's important.
Anyone else? Do you think we could get this to our counselors for input for the board meeting?
Sure.
That'd be great.
I just want to make a comment really quickly to Ms. Leonard's comments there. It just reminded me of when my kid went to South for the first year, incoming freshman, and one of the things that stood out, as you said, is at South, and I'm sure North as well too, is that parents are so engaged with their kids, and that's what makes this district special, because of so much engagement with their students. And I think that, you know, these policies, you know, help with that, because they make sure that if there's anything that's troubling them, the parents are told. Because in most cases, you just want to see your kid thrive. So.
Are we just going around now?
Sure, yes.
I think the thing that I'd like to see added before it goes to the board, I mean, we could move it on to the board and just expect that by the time it gets to the board, these things are added. But I'd like to see some directive to the administration to come up with how the parents are going to be notified and in what way. I think that can potentially address some of Mr. Cox's comments. You know, if it's a mental health issue, for example, not getting into, hey, we think your child came to us and complained about anxiety and depression, so here you go. But, you know, something more general that can help the parent understand that there's something going on, but also maintain a channel of communication with the child. I don't know
Yeah.
exactly what that would look like, but
It could
some.
be a direction to the administration to create an administration guideline based
Yes.
off the policy.
Correct.
I'm just gonna say, every situation is different, so it's really difficult. I'm just gonna use your Harvard example. You know, does a parent have a right to push the child to Harvard, and a teacher has a different opinion? To me, that's a little bit of a level of opinion, and I think that the parent supersedes. And there are certainly teachers that I agreed with their advice, and I didn't, and we talked about that. So it's hard. I think parents should be involved as much as possible unless there's a concern of abuse or that the child is going to be hurt. And even to your point, if I were a parent getting that phone call, I want all the details. Like, I want to know, what do you mean? You say, like, what did they say? What can I help with that conversation? And we'd like to think all parents are rational and are meaning well, and none of us know how to do it perfectly well. There are different parenting styles and so forth, and I just don't want to usurp parents' authority either. I don't want to put kids in jeopardy, so it's this whole balancing act that I think you can agree with, that we struggle with every day. Where does the law lie? We're all here to help kids, ultimately, and we would hope that every parent wants to help kids and every administrator wants to help kids, but it is a balance, because in the situation you said, I think you want something more general. I want something more specific as a parent. I want to know exactly what happened so that I can help my child more. So I don't know that I want to put a guideline in that said be very general with the parent either. So I'm just trying to understand how that would come to fruition and what exactly that looks like. To your point, you don't know how, neither do we. I mean, we all struggle with balance. It's a balance of whose rights, kids' rights, parents' rights, the school, and there is no perfect solution. I would hope that we could all in this room agree with that. There is no perfect solution. And we would like to believe that 100% of parents are great parents and doing great things, but we can all agree that some parents struggle, whether they know it or not, or whether we agree with that or not. But it's just hard to put all of those things into. We have to take all the facts into consideration before we make decisions. So I would struggle with that, I guess that's my point. I think my administrative team would struggle with exactly what that looks like. But I can certainly ask, and I would say our experts, our social workers, our psychiatrists, psychologists can work with that. The professionals, that's not my forte. I'm an educational leader, so I defer to experts always in making decisions like that. So I think you can certainly ask for their opinions, and I can try to encapsulate that or have them write it down, and I can share those all with the board as well.
Great.
I'm not all-knowing on any of this, and I don't pretend to be. Because, I've been in situations where it's a struggle, and sometimes you don't know what the parents know either, right? And so sometimes there's always multiple sides to stories, and it's hard to have a crystal ball to know what the truth is sometimes too. So it's Mr. Schroeder's nursing. It's a hard situation. You don't know everything, and you're trying to get a glimpse of a lifetime in a 5-minute conversation. We can try, but I'm not going to make promises on that. I don't know.
Good. Mr. Cox, anything else?
I shared what I want to share, and you shared my course.
We're not factory workers, that everything is every situation is different.
Mr. Thoits?
Just general principle of parental involvement, I like it. I think it's important that the experts weigh in before the board meeting so it can be efficient. And I'd also like to see legal look at it to make sure Dr. Tuttle's, the judgment call, the balancing act fits within this. And not, we're going to ignore this when we have to, kind of thing.
And I would say parents choose to send their kids, their children to our schools. And I always want to err on the side of not breaking that trust and having robust communication with the parents. They are the decision makers in their lives, as long as they're the guardians. And to encapsulate that and make sure that there is clear direction to our staff. I think it actually helps with staff liability if you have clear direction but also to make sure that we encapsulate that trust with the school system, that we don't break that trust. And I think that that's probably one of my biggest fears, is that if someone inadvertently breaks that trust or on purpose breaks that trust, then we lose that trust with many parents. So I'm looking forward to move this towards the board, and with that advice from the experts in the school system. Is there noted some concerns? Is generally okay to move forward towards the board? Yes.
With the two
Yeah.
caveats.
Caveats. All right. We are adjourned.